And finally, in 2011, the Supreme Court, I think this is the watershed decision, in AT&T versus Concepcion, a standard form contract, the kind we enter into every day, all of us, includes a forced arbitration clause and a class action waiver. And the Supreme Court upholds that provision, despite the fact that California law prohibited forced arbitration clauses and class action waivers as a matter of public policy. So there are two things about Concepcion that I think are important. First, we see that no longer is consent important, because we all know we don't really enter into these contracts with full consent. We're not really reading through and understanding and agreeing to every single provision in the contract. Second, we see this being used against consumers, right? This had been a big no-no, right? Because again, we don't have that sort of equal bargaining power. And third, the state had a policy, California had a policy that class actions were the only way that consumers could vindicate their consumer rights under California law. And the Supreme Court says the FAA preempts that state law.